Please come to order for this April 7th, 2026 regular planning board meeting. All rise for the pledge of allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, in terms of appointing alternates, all our regulars are here tonight, so with the exception of, I think, Middle Ridge, where Jessica was the voting member, Rolf has not been here for any of the discussions, so Jessica will remain on Middle Ridge.
Can I go home?
No. Good try, though. Very good try. And I think that Erica had been on the rest of the items that at the last meeting. So basically the old, I'd say everything except North Star Estates. So, and Stonewall Hollow. You didn't go on the site walk, correct, Rolf?
No, I did not.
But, and we had a sketch plan. I think we'll leave you as the voting member for Les Hill and the Kimball Acres lots, and then Rolf can take over for North Star Estates, because we're just getting into that, and not everybody was at the site walk anyway. And then Rolf, you were involved in Stonewall Hollow. Okay, is that square?
Whatever you want.
All right. Next on the agenda is, it's a long agenda today. Approval of the minutes of February 26th. Do I hear a motion to approve the minutes of February 26th?
Move to approve.
Moved by Ms. Cook. Is there a second? Is there a second? Second by Ms. Lynn. Any discussion? Yep. All in favor? Jessica, you get to raise your hand. 5-0, since Rolf wasn't at that meeting. Next on the agenda is approval of the minutes of March 3rd. We got a request from Mr. Lopez to modify the minutes. Has everybody had a chance to read that? Are there any comments? Mr. Madsen?
I think that since we're asking to change the minutes of what something was said, and we're kind of lucky because we got all our minutes on tape, our meetings on tape.
Yeah.
I think before we approve these particular minutes or approve the change, the board should review the tape and make the decisions after they review the tape and take it up at the next meeting.
Does anybody have a problem with that? It seems like
That's a good idea.
wise thing to do in case it impacts anything downstream of that. So, so I guess I'd ask everybody to review the tape, which is,
I'd like to make that as a motion, Mr.
yeah, I'd accept, so you made the motion, Rolf?
Yes.
Mr. Madsen makes a motion for the board
Review the tapes in
from March
response
3rd.
to the letter that we received.
Yep. Is there a second? Second by Ms. DiPietro. All in favor, please raise your hand.
Yep.
You don't raise it for this, Rolf, but you're okay to make a motion. Okay? Next on the agenda is the minutes of March 17th, which was a workshop?
The sidewalk? Sidewalk.
Site walk, excuse me. That was for North Star Estates on Ohio Ridge. Do I have a motion to approve those minutes?
Can I do that one? I wasn't there, so I read them.
Somebody that was on the site walk might want to do that.
I was on the
Okay.
sidewalk.
Moved by Ms. Rowland, seconded by Ms. Lynn. Any further discussion? All in favor, please raise your hand. Thank you. Okay. Next on the agenda is public comment. This is typically comment for items not on the agenda. Go ahead, Mr. Lopez.
Good evening, board members. Mark Lopez, 438 Commons Drive. I've been to a lot of planning board meetings where I've heard the term consistent by this board. And I can tell you from an applicant's perspective, a board that's consistent is very much appreciated, and it's very important. It's important because there should be some predictability in the outcome of an application process, which has been of an application that meets the standards that have been objectively and consistently applied by the board to past applications under the same review standards. Now, with that said, I've reviewed the application process and decision for two fairly recent applications. One is for a 17-unit project on 9.82 acres of land located on Mountain Road that was approved by this board in April of 2023. 3 members of that board are still members today. This project was built in close proximity to the wetlands, so close, in fact, that a retaining wall was required to allow the construction of the project without filling wetlands. From the minutes of the meeting, there were concerns raised about wetlands and wildlife. I cannot, however, find where a hydrogeologic study was required, nor can I find where there was even any discussion about the need for such a study in the minutes of the meeting. Now, this project was approved with common water and shared wastewater disposal systems. The terms common and shared are not my description or definition of the water and wastewater disposal system. These terms are not how I interpreted the land use standards, and they are not terms I found in the definition section of the land use ordinance. The terms common and shared are, in fact, the terms the board used to describe and define the water and wastewater disposal systems. The terms came from the board's interpretation of the land use standards in order to facilitate the unanimous approval of the project. From the findings of fact and conclusion of lot number 11, which the record reflects were drafted by Chair Brusini, the proposed minimum density requirements are reduced to 5,000 square feet per dwelling unit, given that the duplex units will be served by a common water system and shared wastewater disposal system. I'm not saying the board made an improper decision with this application. On the contrary, the board absolutely made the correct decision because that application objectively met all of the review standards in effect at the time of the application, as evidenced by the findings of fact and conclusions of law. The land use ordinance has not materially changed since the approval of this application. Central water and central sewer were the criteria necessary for the reduction in lot size to 5,000 square feet per dwelling unit in 2023, just as they are today. So based on the above, if an applicant submits a proposal that's substantially similar to this proposal, which was approved by this board, the applicant should reasonably expect to have a similar review process, a similar application and interpretation of the standards, and a similar result. Being consistent requires an equal and objective application of the standards. Thank you. And I'll hand this to the board. This is number 11 that I referenced in the findings of fact.
Yeah, but you could give it to Laura Lee, please.
Okay.
Thank you. My only comment is, to my knowledge, the subdivision regs did change in October of '23, so.
Not materially. Okay, but you can check that.
Yeah, I guess that's something that we'll look at for the future
Okay.
in workshops. Anybody else? All righty.
Yeah, but I would just say to Mr. Lopez that his comments are duly noted.
Thank you.
Thank you. All right, old business, Kimball Acres lot split. We have the findings of fact before us. However, before we get to that, I understand that somebody would like to speak to the board before we get into voting on those findings, which are for the, well, we were doing the preliminary and the final together, but go ahead. Could name and address, please?
Jessica Couture, and I actually live at 8 Royal Coachman Shapley Way, but I just purchased lot 18, which is in question on Kimball Road.
Okay.
So we were never notified when it came to this happening for it. On December 29th, we actually have the deed recorded with the Registry of Deeds, and they also stated that there was a CD distributed in December, and the email was sent to actually Sean Day, who we verified today did receive it in January. The assessors did not enter our deed into you guys' database until 3/18. That's March 18th, which it should have been done back when it was actually done, sent to you guys. On March 3rd is when the proposal with the planning board was actually made. We were never notified, and that is a huge infringement on our property. It affects our deed, and we'd like to know how we can go about, figuring out how this will eventually affect our deed and what's actually going on and why we never had a say.
So let me clarify the procedure. You said that the deeds were updated, or the tax maps were updated on the assessor's site in March 18th.
No, that's when you guys registered it. It was sent to you guys in January.
When you say us guys,
Sean Day. We spoke to him today, up there, the tax assessor.
so it was sent, when you say you guys, you mean the assessor?
Yep.
Okay, so this board does not have authority over when the assessor enters items into the system. The only thing we have authority on is what's in the ordinance.
Okay.
The ordinance directs us to go to the assessor's site to get the tax map and lot number of each owner within X distance of, in this case, it's 500 feet. So when applicants notice people, they have to use the current assessor's site. And that does, if there's been a recent transaction, it will lag behind. So property.
When applicants notice people, they have to use the current assessor's site. And that does,
Wayne,
if
mute your
there's been a
phone.
recent transaction, it will
Hey, Wayne!
behind.
It's
So,
lagged.
property.
It's Wayne. He's watching. And there's a
Nobody wants to
delay.
hear me twice.
You should be able to.
Sorry about that.
So that's the way I mean, does anybody in the board want to mention anything? That doesn't mean we won't address your questions.
Yeah, our main concern with that is that the fact that we weren't notified And how is it going to affect our deed? That's all, because we have a 50-foot right-of-way. We see what's being asked. We have no problem with what's being asked. We just need to know how it's going to affect our deed.
So my understanding, having, okay. Brenda, do you want to come up here? So my understanding, when we last looked at this, is if we go to, find the map. So have you seen this map?
Yes, I saw it today. The first time I had seen the map was today. That's what I mean. Me and my husband were not even notified. He actually spoke with with the homeowner to who's requesting it, and he didn't understand, like, he's not me, he doesn't absorb as well. So that's why I ended up making an appointment with Brenda today and found the map she gave me.
I think procedurally for the board, well, we didn't have a hearing, we just have to, I don't know if we reopen the evidentiary period or we just say, you know.
The question is, was
When
the
it was
notice
noticed.
proper? Was the notice?
Yeah.
Notice was proper.
The notice was proper.
She got hung up, go ahead, Brenda, this lady got hung up in the time lapse between when something's sent to the assessor and when the assessor posts it on the site that we are required to access.
So the assessing files are only updated quarterly. So when somebody goes on and gets their abutter list, it may not be up to date, but our ordinance does state that it has to be notified of who's on the tax record. So we verified with Sean today, it did not get recorded until March 18th, which sounds about quarterly, because it was done in December. So every quarter, they update all the files to current, to what they have. I mean, this can happen, I mean, we had one
where the guy died.
Well, we actually had one where it switched people 3 times before we got recorded of it, so we missed 2 of them, in the update, because, sometimes lots switch quickly, but it is every quarter that they update.
Yeah.
And according, so the ordinance was followed because they were notified to the tax assessing files.
So I'm thinking, is the applicant here?
I am, and I was wondering if I could actually answer what the main concern is, which is how it would affect their property, which is none, because I'm perfectly happy
Okay, hold on
acquiring half of
hold
the...
on one second. So we had findings of fact and conclusions of law. What I'd suggest to the board is that we put aside voting on those, and we essentially restart the review, which, if you remember, was a very simple review because it was just a land conveyance.
Does that hold up their timeline at all?
For these folks?
Yeah. I just want to understand that impact.
Well, has everybody had a chance to review the letter that was uploaded just for?
Excuse me,
The letter uploaded, has everybody reviewed that?
well, that's a different one.
Oh, sorry, I'm sorry.
I mean, this woman now has notice. I mean, I think we have 2 options. We push this back, or we just review it tonight and get the questions addressed.
Is there property being affected?
My
That's-
opinion, no.
That's what we don't know. That's what I'm just looking to
That's
see
the
if the
question.
deed's affected.
That's the question.
So I understand, so you're the applicant, right? All right.
So if this person is satisfied that her property is not going to be affected,
So why don't you,
It's properly noticed.
why don't you
Is it properly
explain where
noticed?
your property is
On the map,
on the map to the board?
the easement we are granted is from here to here, from her actual lot parcel, the actual lot 4.
Yep.
And then we have all of the acreage, almost 6 acres in the back of it, which we acquired from Mark
Okay.
Lopez.
So this easement is, as it says on here,
Yep.
a right of way.
Yep, we have to put a road through it due to the amount, the footage that it requires down through. And we just, we don't know much about, like, what is going on. We were not ever informed, that's why we were just looking to see what it would affect, if it wouldn't affect anything or what.
So if this is,
We have no problem with it.
if this is a right of way easement,
Yep.
which it says on this map, I believe,
Yeah, I have the deed too, but I can look that over.
it's right.
Yeah, it's this one, right? So the light line. Right here. And the light line.
So here to here is still the right way.
Correct.
This is what she's.
This is all the, this is the right of way here,
The right of way.
okay?
The whole thing is.
The whole thing.
Yep.
So, a transfer of land,
It's deeded, it's a deeded right away, correct?
Oh, yes, I have the, right here.
The right-of-way is not going to change. The right-of-way stays the right-of-way. The planning board is not changing the right-of-way. What's changing is, Lot 4 is purchasing half of the right-of-way, so that her setback is different, so she can build up to the edge of the right-of-way. Not within the right-of-way, but up to it. Because she has 25-foot setback, she's trying to build a garage. So the question is about the deed. The deed can't be done until this approval is done, so they're gonna have to do new deeds done.
Would our verbiage stay the same as our current deed as
Okay.
well?
Thank you, Brenda.
yep.
That's the other question is, with the deed, with it being done, would the verbiage stay the same as it, or would it be changed at any point in time?
Well, it shouldn't, I mean, if that's a right of way easement, then a proper lawyer is going to, or whoever does the deed is going to reflect that. You can't take it away.
Okay, that's all we were just wondering.
Yeah,
New
it
to all
can't
this, so
be
it
taken
doesn't hurt to ask
away.
questions.
It's your right of way. It's whoever, it's a right of way, period, from here to there. If Ms. Waterman and Mr. Waterman, they can't put a garage on their property right now because it would bump into their lot line and they wouldn't have enough setback.
Setback.
They need 25 feet, so they're buying 25 feet. And
In order to keep what they want on their lot for, is that how I'm reading it, right?
Correct.
Okay.
And it will not, and in doing that, they're buying a section of the easement of the right-of-way.
Okay.
But there's no, they can't do anything in that right-of-way. They can only go up to their,
Okay, so we'd still be completely responsible for the whole right-of-way, if I'm hearing this correctly?
It would depend on what your deed says.
yeah,
Yep, that's what the deed says.
yeah, did you say you'd still be responsible for the right-of-way?
Yes, we were given all rights to the right-of-way.
Okay, so you still have, yes, you still have a
It's not
right to
taken away.
use the right-of-way.
Okay, and then we have to keep it maintained and everything else that the verbiage says.
I mean, I haven't
Okay.
looked at your deed, but I would assume since it's a right-of-way, it allows you to build a driveway into that or a road into that.
But none of us are
Yeah, there won't be
attorneys.
any.
No. So if it's an existing one, it should remain an existing one.
Okay.
And I do remember when this came to us, Mr. Lopez used to own that property, and that was
Yep,
placed
so we
there
bought
on
it from him.
purpose so that it could be accessed. Erica, did you have a
I
question?
do have a question, and that is that if you're, so it's a right of way for all intents and purposes for you to access your lot. Are there any, and I probably should know this, but I don't yet, are there any setback requirements for actually establishing a road? Because I'm just curious, like if
I see,
these
yeah.
folks are building, these folks are
Leave it
acquiring
distance
part of the
between.
right-of-way space to build their garage, and then these folks want to actually construct their
Driveway,
their driveway road, is there any setback requirement, like any space that's gonna be required between the garage and the road? And
Yeah.
does the right-of-way, is there enough width in the right-of-way to accommodate both?
It's a 50-foot
I
right
think
of way.
It's a 50-foot
It's a
right-of-way.
50-foot
So
right-of-way.
you can probably slide your thing here.
Ms. you want to speak to that? I think you're one of the driveway or road experts. So,
Say that again?
so it still remains a 50-foot wide,
Yeah, from what I
Right-of-way.
understand, it's a 50-foot right-of-way, that is
Okay.
correct. They're only going to be building a 20-foot driveway.
I have the grant of easement if you guys want to read over it as well.
I think we just need that for the file.
Yeah. Okay.
Does that answer your concerns?
Yep, for the most part, as long as there's nothing that's gonna impede our deed or change our deed, I mean, I guess it'd be fine.
I don't, yeah. Do you
Just
want to
like-
say something, Ms. Waterman? You're the applicant.
I was never informed is the biggest thing, so I didn't have a clue what was really going on until I came here and had a meeting.
Yeah.
So we just wanted, kind of get your ducks in a
Well,
row.
we all wish the assessor was faster sometimes, to be
That would make
honest.
life easier.
Yeah. Ms. Waterman, do you have any comments? You need to go to the mic, so,
You don't have to. I mean, I guess not at this time. I feel like it was pretty.
need to go to the mic, please. Name, please.
I feel like you guys pretty much covered it. We're kind of purchasing 25 feet of land we can't do anything with. We're just doing it to push our property line out so we can then build on what is right now our current property we can build a garage on. But we wouldn't be able to build into the right of way or touch the right of way.
Okay, I understand that better now.
So, the board understand everything?
They can't build in the right of way.
Yeah, right.
She's
We're doing it so we
purchasing it
can
for the
build on our
setback
current
reason.
You
property.
can use the right of way as,
Yeah, they
Access
want
and-
to, they want to go to the edge of their current property line.
Yeah.
So that they'll be 25 feet
Yeah.
away from the new property line, and they can't do anything in that 25-foot
Right.
swath. All right,
We're good. Understand.
so what I would suggest is that in the findings, which you have in front of you, I think we might want to put maybe a condition in here that the right-of-way must be the current right-of-way must be maintained as a right-of-way. I don't know how else to put it.
I think maybe we should put something in there too, Deb, that, nothing can be put in that right away, so no, I may understand.
right of way may not be impeded in any way.
Yeah, my understanding, I don't know 100%, but there is a fence in the right of way. The fence cannot be in the right of way. It needs to be to the edge of the right of way. It can be right to the edge, but it can't be in the right of way.
Okay, so I think under the conditions of approval, we would put something that the existing right-of-way
Can have no impediments.
may have no impediments. How about the existing right-of-way shall remain
Wordsmith.
and shall have no impediments.
That it inhibits its use.
Should it just be no impediments, period? Just in case somebody argues about what inhibits its use. Anybody?
Can you just read it back one more time as the full sentence?
The existing right-of-way shall remain and shall have no impediments.
Can we just refer back to the easement? There is a right-of-way, and that's pretty clear on what can be done in that right-of-way for maintenance or...
That's probably the
That's
better
what I was
way to
gonna
do it.
recommend, as described in whatever deed reference it is, the existing right-of-way as described in.
Yep, that's
Okay.
the deed reference, because that'll,
Let's see if we can find that. I don't know that.
it might be, the deed reference might be right on the survey plan.
The easement is in the registry of deeds, yes.
Because right now it's part of that other lot, right? So.
We have to look at the old.
We've got a copy over here.
Okay. I think we have to look at the old map, which is in the prior one, for the Kimball Road original subdivision plan. In that one,
I don't think there was anything in the deed.
okay, in that one, it has, on a prior, on a prior application, the one that created the subdivision, it's got some easements. It has proposed 50-foot right-of-way. Does that deed that was handed out have that on there? It has a Central Maine Power Company easement,
It's a separate one.
but that's different.
I think what you guys are looking for is what she tried to offer you.
Yeah.
It's newer. I don't think it was written up in the original plans. This is their agreement with the current property owner.
Can I see that deed for a moment? It's either that or
The CNP has already been there, it's been there since 1960 something. There's many pieces to this deed, because their mortgage company actually has to sign off before anything happens. I don't know which part you need.
which is, okay. So this is what I propose to do, so that, because I don't want to mess up. What I propose to do is that we reference the deed, but that Brenda will go over the deed and be sure it's the right deed in terms of referencing. It's either that or we just wait, and we wait, I look at it, write it, and then we go over this again.
Just move it along.
Yeah.
So, Ms. Day, could you just look at, it, instead of me taking the time to do it here, could you do that?
I'm not supposed to interpret deeds. Code enforcement, sorry. I'm just
All right.
telling you, it's out of my league. I'm not an attorney, Deb.
Could I see that deed again, please? We just might have to,
Which part are you specifically trying to find, because I
where it's recorded.
recorded it a few places.
Okay, this is Mark Lopez
Yep,
to
that's the
you.
original one to us. Yep.
What
Here's
is
the
it that you're
grant
looking
of-
for in the deed?
This is the new one for the split consent. So this is where it gets here. So this would be him that gave up the property, it's this person.
Norway Savings Bank.
Yep,
I
it's
think,
not even Stephen Morris, that or Wesley.
yeah, it doesn't matter, yeah. This agreement made this 5th day of December,
Yeah, well, so
and here grantor low referred as grantee, grant of easement.
I don't
Can we
think
send this, can we, I think either, somebody needs to look at this, that's just not me reading it here.
Yeah, I also think that, I mean, the planning board already granted a 50-foot right-of-way. I think this is out of our league.
So,
Because the original plan had a 50-foot right-of-way.
correct.
The new plan has a 50-foot right-of-way. As far as the planning board is concerned.
It has a
nothing-
50-foot right away.
Correct.
All right, so,
Anything further than that, I think would need legal from the applicants, not from the town.
okay. All right, so I think we should just leave it the way we had it then. The existing right-of-way shall remain and shall have no impediments. Rolf, except, if we want to say to its use, that's fine, but no impediments, period. Does that work for everybody?
Yes.
Okay. Then in that case, I would accept a motion to approve the findings of fact and conclusions of law for Kimball Road, map 19, lot 18, for the subdivision amendment with that change. Is there a motion? Moved by Ms. DiPietro, is there a second? Second by Ms. Cook. Any further discussion? All in favor, please raise your hand. Okay, you get to raise it on this one.
One down.
Oh, never mind, you signed it. I'll get this to you at the end of the meeting. All right, next on the agenda.
Yes. Do we want to sign her site plan? She has it in her hand.
Oh, she has the site plan? Yes, go ahead and lay it out there and I'll sign this while you're at it.
We can take that one. So it doesn't get confused.
What's today?
They gave me some copies, so I just want to make sure.
We usually sign them all.
Oh, okay.
No more Stacy.
What's that?
No more
Make sure I have the right one.
One Stacy.
We sign them all, one stays here.
Okay.
I'm not used to it being here. It's- set. Yeah, just sign right below.
We're yours.
All right, I think we're all set there. Okay. Next on the agenda is the Middle Ridge subdivision findings of fact and conclusions of law. Yes, Mr. Lopez?
Good evening, board members. Mark Lopez, 438 Commons Drive. Before we start with this tonight, and in an effort to end the application process tonight, in light of the information that I submitted during public comment, I'd like to know if the board, or any board member, would like to reconsider how the term shared was applied in the findings of fact and conclusions of law on Mountain Road, and how it was applied here. The term shared was used in interpreting the land use ordinance on Mountain Road to permit the application, while the same term was used by the same chair in interpreting the same ordinance to prohibit the application that has half the unit density and is 30 to 40 times further from the wetlands. So, I'll reread number 11, or portion of number 11 from the findings of fact, where it says, duplex units will be served by a common water system and a shared wastewater disposal system. That's the fact and law of that application. So you can understand how an applicant, when submitting an application similar to this, might expect that they would get a similar result. So I guess my request is there anyone on this board that would like to reconsider how that term was applied so differently?
Yes, I do think that we need to clarify some of our terminology, because we're seeing central water and central sewer as a term. We're also seeing common and shared as a term, neither of which have, as far as I know, definitions under Maine law. Whereas we have comparable, which used to have standing under one Maine law and now is under another, and means something quite different. So we do have a terminology problem. I will grant you that.
Right, I mean, I don't understand how if I didn't come to subdivision, I could be building another duplex right next to it, then in 5 years I could break off another one. I don't see where the logic is in that process. And, Rolf wasn't here at the last meeting when I said, the purpose of planning is to try to should be to get the best outcome. And I don't think we're getting the best outcome here. And I think we'll see that at some point.
I think.
So my request is simple. Is there anybody that would like to reconsider it? If there isn't, well, I'll get out of the way and we'll move on. But this won't, I'd like to end this process tonight, and I can tell you, as sure as I'm standing here, that won't be the end of it.
I think it's hard to reconsider on something that some of
It's
the
not.
board.
It takes a motion, and it takes.
But you're
a show.
asking based upon a prior application.
I'm asking
comparison to that.
based on the board's desire, the stated desire that I've heard them say before, to be consistent. Now, the board clearly has the latitude to say this works. It's been done in the past. I did it right down the street with 2 other duplexes. Okay, so that's my request. If no one wants to do it, then that's fine. I'll sit down and we'll move on.
I was not on this board for that
I
other
understand.
review.
Yeah.
And I would need more time to better understand and consider the legality of it, I don't.
Yeah, so.
It feels above and beyond
in-
something that
in-
could be
in the past,
here.
net buildable land, when those were built, net buildable land was not part of the calculation for lot size. So,
Right, and when we,
and it wasn't, and it also didn't say per dwelling unit in that standard. So the standard did materially change.
it did say per dwelling unit, it was 40,000 square feet per dwelling unit. And when you went to net buildable land, I stood here just like I am now, and I told you guys this was nothing but growth control, and we're seeing that come through now. Okay, this is just a way to control growth. If it wasn't for net buildable land, we wouldn't be having this discussion at all. Okay? This is an application that's 30 to 40 times further from the wetlands. And you guys, I don't know what you're accomplishing there. If you're trying to protect wetlands, you're not doing it. If you're trying to protect density, it's not gonna happen. So if there's no one that wants to do it, we'll just move on.
So,
So Mark, what do you want to do?
Rolf, what I wanted to do, thank you for asking, is the original proposal was on 80,000 square foot lots. Now, you weren't on the site work, I know that. I built one duplex there on an 80,000 square foot lot, which I could do. It's identical to these other lots. I built one duplex because I didn't have to come through the subdivision process. Divided the lot, went to the code officer, got a permit. Came in, wanted to do 4 more identical projects, okay? And the reason we're doing this, Ralph, is because I don't want to have to build houses to have to sell for $400,000 to $500,000. We're trying to do something that's affordable to people that work in this town, the first responders, the school teachers, the first-time home buyers, okay? $400,000 to $500,000 is not affordable anymore. We're trying to get the price well under $300,000. And because we have net buildable land, the board is able to chime in on this and say you can't do it. Okay, it makes no sense at all. Okay, and that's in the board also, in my opinion, clearly had the latitude to apply the terms common and shared, just like they did on Mountain Road. Okay, and they use shared, I won't even argue that one, we use shared, that came from the chairman, you'll see that when you watch the film. Okay, that's what I want to do, I want to build 4 more duplex units. Okay, and Ralph, you weren't here when I said the last time, there are alternatives, so as I read the proposed findings of fact and conclusions of law, what this seems to be doing is saying, okay, you build one giant septic system, you put a centrally managed water system in, you can get down to 5,000 square feet per dwelling unit. I could put 20 units there, okay? I told the board at the last meeting, I contemplated doing that at the beginning. I'm doing this with my son. This is for NTGM Investments, we're working together. I said, listen, I don't want to do that because it's going to be a fight. I said, let's do something easy. It should be, open and shut case. It's not. Okay, everything is turning into a fight, and I don't get it.
I don't see how so first of all, we don't set precedent, and in order to.
That was so predictable, so predictable.
Okay, does anybody want to, so we're going to go back and we're going to go review the tape. We have to review this on its own merits. We can certainly go back and look at the other application, but it would require the board to go back and actually look at the context of that application.
Which one are we talking about?
It's the Mountain Road application with the 17 condos.
Dan's place.
So,
And when was that approved? I wasn't on this board with us.
2023,
And
Was it before June of 2023?
I'm not sure.
Oh, because I don't remember.
I think that we should review the tape for this application based on Mr. Lopez's comments about shared, and then see if that materially affects the findings of fact and conclusions of law. That's my recommendation.
I agree with Kathy that we've got a problem.
Yeah, absolutely.
And I think what we should do is, we're going to take a look at the minutes and review the minutes. I think once we do that, I think we should take a look at this next meeting and address what your concerns are.
Okay, I'm fine with that.
Yeah, we can't, just a comment, the minutes can't replace the findings, but
I'm not
I'm just
suggesting.
clarifying.
I'm
Wait.
suggesting that we've got an issue with semantics and language. We need to fix that.
Fix it for this decision or fix it for future decisions?
Well, future decisions, I would assume.
More consistency.
For definitely future, but we need
Yeah.
to take a look at whether it affects this particular decision as well. I think that's, as I said to you, duly noted.
Thank you.
When can we ask a question, or do we need to go back? If we're curious about the details of the Mountain Road subdivision and the approval and what that shared in common water system and sewer system look like, do we go back into the minutes?
I think
to
that's a
look at
question, I think that's a question for our attorney, to be
Yeah,
honest.
I'm just curious.
If we
Like,
don't-
and
if we
that's
don't
just gonna
set
cost more
precedent.
money. Application.
That's what we're,
I don't know, I'd like to know what the details of the shared and common systems were that were approved, and then
I
to
think,
understand
yeah,
how that language was applied.
correct.
Yeah.
Yeah, listen, I don't
I don't
want you
think we
spending
can
any
do
money
that
on legal
tonight.
fees. We spend too much money on legal fees here with this planning board. It's taxpayer money. Just make a decision, and if it doesn't go my way, we'll regroup and we'll come back in and see you with something different.
I think we've got a go-forward plan, which is take a look at what the language is, discuss it next meeting, and make a decision which we're, in the interim, if somebody wants to look at that particular project.
I think we have to be careful comparing projects, because it was a different
I don't
project.
disagree with you, Deb, but I'm
Yeah,
also,
okay.
because the timing, the dating is different.
Correct.
but if this, I don't mean to interrupt, but if he's building something similar to that project, why couldn't we go back and reference?
Yeah, or if the systems, what I'm curious about is if the systems, because your
Right, because-
question
Well, we
hinges
would,
on the.
I think the whole thing would, it would have to be reflected in the findings of fact and conclusions of law that we did that we actually went back and compared this to something else to make a decision. I think maybe a place to start is what Rolf suggested at the beginning, is we review the tape. Mr. Lopez has asked for a change to the minutes, decide whether that's accurate and whether the minutes should be modified, and then decide if the minutes are modified, does it materially affect the decision? That's, I think anything else we do is conjecture right now.
So I guess we got something to do on our next meeting.
I think we'll have some other stuff too.
Yeah.
Thank you.
Just 1 minute, please. All right, that is.
On 5C,
Yep, next on the agenda, Les Hill, Isaac Stevens subdivision amendment. Is the applicant here? Or the applicant's representative?
Hi, my name's Jed Scott with Sebago Technics, representing Les Hill. Came here a couple months ago to do a lot split of Lot 1, and I think at that time there was some questions about what type of wetlands and some phosphorus calculations that just needed to be refreshed on our proposal. And so then the main point of this application is to remove the restriction from the previous subdivision restricting the lot division of lots 1 through 4. And so I believe the client's attorney sent out letters to the abutters, just requesting any feedback on that.
Yeah, so we got a letter from their attorney. So to take the board back as a reminder, we were concerned about, on the plan we had, it said lots 1 through 4 could not be split. And that map matched up to another map with the same name, Les Hill subdivision, and it says it right on the map, matched to XYZ map. So put the two maps together, there were 12 lots there. So this board was concerned that we were removing a restriction that was an agreement, potentially an agreement. We had no subdivision plan with any details other than what was on the plan. So there was a concern that essentially removing that could lead to some legal issues, the way I remember it. Kathy, does that
Yeah, I
sound?
remember pretty much.
So we've got something from the attorneys that came in at 4:15 today. And I would just ask if we could please get these things in time to read them in the future. I guess the attorney for Les Hill here, I think the bottom line is this letter. Maybe you could go over that for us?
Molly?
Ms. McGuire, is that correct?
That's correct. Good afternoon to the board and those in attendance. I just wanted to state that I do believe that Mr. Hill's proposal is adequately supported by the material submitted by Sebago Technics. Jed had requested that I attend this afternoon in case there were any questions from the board. So I did submit a statement just to anticipate possible questions. Essentially, my letter confirms that the board does have authority to make amendments to an existing recorded subdivision plan. And in this case, the proposed amendment would be supported by, again, the material submitted by Sebago Technics. Essentially, the requirements under the land use code for the town of Bridgton states that the amended plan must comply with various sections in the existing code, namely that all the criteria listed in section VI4 for preliminary subdivision plan applications is also addressed in the amended plan. Furthermore, a proposed amendment must satisfy additional requirements codified by state statute, 30A MRSA section 4407. Those requirements rather are actually identical to the review criteria in the land use code for the town of Bridgton under section VI6, which is an additional requirement. It appears under the land use code there are additional review criteria that are not applicable in this case. This subdivision is not a mobile home park, a condominium, land use development, or cluster housing. The issue of notice was raised, and I think the board adequately summarized the possible issue in this case where we have two separate subdivisions, but where the second subdivision could possibly be interpreted as a continuation or a part of a common development scheme. Both subdivisions were created by the same developer, and as I believe the chair indicated, The second subdivision plan does reference the first. The original subdivision plan, of which the applicant is lot 1 of 4 lots in that plan. The second subdivision picks up at lot number 5, so that could be considered a continuation. So my firm did submit notice to the various lot owners, both in the original subdivision plan as well as the additional subdivision plan. I believe some of those folks might be in attendance today. I would just note that in the original subdivision plan, Tad Putney, who is on Zoom, I believe, he is a beneficial lot owner of lots 2 through 4. So essentially, in the original subdivision plan, all of the lot owners, the Hills being the owners of lot 1, as well as Mr. Putney and Ms. Keller being the owners of lots 2 through 4, they're all in agreement with the proposal submitted. Mr. Putney and Ms. Keller also own lot 5 in the second subdivision, of which there are lots 5 through 12. I have separately been notified that the owner of lot 8 is not in agreement with the proposal, and I did indicate him that I asked him to, if he had any additional information he would like the board to consider, that he should reach out to the board directly.
Okay. So I think the reason we believe lots 1 through 12 are the same subdivision is because of the 2 maps asking to be matched up. But I understand what you said. Does the board have any questions for the attorney? Ms. Day, do you have any comments regarding this from a board authority perspective?
I guess my only concern with this would be that, in my opinion, it's covenants related. And if all the lot owners are not in agreement, I'm concerned with that.
I think that was our original concern. So I guess it's very unclear, at least to me, whether this restriction was based on an agreement between owners at the time or whoever developed the lot, or whether it was because of stormwater or something like that. It's not clear at all. And I don't know if anybody has the history of that. If it's in a covenant that's an agreement, or if it was an agreement between parties, then I tend to agree with Brenda. Is there anybody, are you the owners of Lot 8?
No, lot 9.
Lot 9, would you like to speak? If anybody could give us some history, that would be helpful.
Well, I guess my first question is, I don't know exactly what they want to do to that lot.
Okay, speak up a little bit and,
My first question is, I don't know exactly what they want to do to that lot, but living there, I know from all the way up at the top of the hill on lot number 1, there's an intermittent seasonal stream that comes through that is great quality of water that could be disturbed by multiple units, whatever going on there. There's also a vernal pool. I don't know if that's on lot 1 or lot that they're speaking of, or the adjacent lot to that. I'm not sure. But why was that in there that it should not be further subdivided? At one point, it's like we are totally against that.
okay, and you're the owners of Lot
9, 600 Sweden
and the
Road.
owner of Lot 8 is also against it. And, all right, and your rationale again is?
Well, there's a lot of water issues that, if we put in, again, I don't know exactly what they plan on doing that lot. I haven't seen that. But there are different water features in there that could be disturbed if you take a 5-acre lot and all of a sudden you're breaking it down to maybe 5 lots. Plus if you put 5 dwellings on a 5-acre lot, it had, 1 dwelling has an impact, 5 has another, and if every one of those puts an ADU on top of that, there's a lot of problems there. There's already, we are in a drought situation. I could go on, but you probably already know all those things that people reject and, object to.
How about
I'm her husband, Jeff Wood.
Jeff Wood?
Yeah.
Okay.
There's also aesthetic reasons. We moved from upstate New York 8, 9 years ago because it just got way too crowded and overbuilt for us. What you've got going up that road is, on that side of the road, has been 5-acre or so lots, which is what ours is. And most of the houses are set back from the roadways. If they subdivide that, even though it's on a side road, it's going to be much smaller units. And again, we have the concerns about the water quality because all the water comes downhill to our lot from there. So I strongly suggest that we don't allow this, that at most they could build one more house in there.
Thank you.
Okay. We did get a submission of a phosphorus study?
Yeah, there's a phosphorus control plan. Yeah, phosphorus report in the packet. Yeah, and there's a phosphorus control plan on the plan itself.
Is this just for the 2 lots, the impact of the 2 lots, or the 1 lot if it's split? Or is it taking into account the entire subdivision?
It's just lot 1 being split.
Okay. Questions and comments from the board?
So it's 1 5-acre lot that they're wanting to split?
Correct. And it's lot number 1, and the plan says,
Just want to make sure I understand that.
I mean,
The current lot with covenants that say it cannot be.
well, it's on the plan. We don't know we don't know why it's on the plan. I don't think.
And it looked like it was maybe penciled in.
Well,
approval.
everything on there was penciled. It doesn't matter. It got signed off by the planning board.
Yeah, no.
1990.
In 90.
Yep, that's what it says.
I mean,
Can we ask what they want to do with all that?
thought.
I think they stated they wanted to, so this is just the plot of lot 1 and the stormwater. And I think it was stated somewhere, I don't remember if it was by the attorney or by somebody else, that the desire was to give the other parcel to their children. Ms. McGuire, is that the case?
Can you restate the question? I apologize.
The question was, why do the Hills want to split the lot, and what are their plans for it?
I believe Jed may be in the best position to answer that question.
Okay, and where's Jed?
I'm right here.
Oh, you're Jed, okay.
Yep. I believe they would like to build single-family homes on the lots.
A single-family home.
Or market them.
The letter on February 26th says proposed a lot split for 2 single-family residential lots with frontage on Isaac Stevens Road.
Say that again, please, Jessica. Maybe get the mic closer.
The proposed lot split for 2 single-family residential lots with frontage on Isaac Stevens Road.
What are you reading, Jessica?
This was a letter sent February 26th.
From our
This is,
application.
yeah, this is within the application. It's like page 2 or 3 of the application.
Maggie?
If, speaking to consistency,
Gonna have to speak up.
so speaking to consistency, the original subdivision was approved and said there would be no future lot splits. That it feels like if we approve something today with that, we would have good reason to do that, and it just feels like to go back and
And we have no
change
history,
that
we don't know.
is, like it says, that it is clearly, that was the intent of that
There shall
original
be no
subdivision, that
future
it would not
division.
be further subdivided.
Right.
Great. That's a good point.
And it says right here that there shall be no further subdivision of lots 1 through 4.
And we really don't,
I just don't know how, like.
we don't know, we really don't know how, if that was a planning board stipulation or if that was an agreement between people.
Well, what we have is written down.
Exactly, so we kind of have to go by that.
May I make a comment as to that?
Sure, go ahead.
Thank you. I just wanted to reiterate that it is within the board's authority to make changes to a amended or a recorded subdivision plan. In this particular case, the original subdivision plan was actually previously amended to change the boundary line between lots 1 and 2. So I do believe it's within the authority of the board if they're willing to strike that note 5 from the original subdivision plan. I will also state, to the extent helpful, some of the deeds did have a list of covenants. It looks like there was possibly an attempt to create a declaration of covenants or a homeowners association. It wasn't done the way you would typically expect. In this particular case, the lots that have covenants attached to their deed restricting the further division, that would be included within the deeds for lots 1 through 4 in the original subdivision, as well as lots 6 and 7, I believe. So that covenant wasn't included in all of the lots, just in a few of the deeds for some reason.
So that's our catch for some reason.
Well.
So it's in the deeds for lots 1 through 4 and 6 and 7, did you say?
Let's see, 1 through 7.
1 through 7.
I
says
would
1 through
note
4
that,
here.
obviously, the Hills are the owner of Lot 1, and then Mr. Putney and Ms. Keller own lots 2 through 5 and are in agreement. To the extent, though, that there's a restrictive covenant in those deeds, that would provide a separate cause of action. So I believe that's a separate inquiry from the inclusion of that exception on the original subdivision plan.
So we're being told that this is going to be split to put 2 single-family homes, and those 2 single-family homes are allowed to put an ADU on
Correct.
that property as well. Am I correct in that?
Yes.
Okay, so that is, possibly could be 4 instead of 2.
Correct.
So,
An ADU can be
Yep.
attached within the home
so
or
technically it would
detached.
be 4.
Public or.
Well, yep.
Now, but we're just judging the lot split, and if a structure is built there, does it meet the specs? When somebody wants to build a home, then they're going to go to the code enforcement officer.
Yeah, but
Yeah, go ahead, Angie.
Well, I just feel like, okay, they get the plot of land where in the future they want to sell, and somebody buys that land and comes in and puts apartments, or, I mean, would that be a deed thing, or?
I do have a concern, yeah.
Okay.
It would be, well, it depends on what it was, and
Right.
it's a subdivision that's been approved with restrictions, which are also on the deeds.
Right.
And it's on the plan, and we're being asked to remove it based on specs for the subdivision, which it, includes, all the technical stuff.
The other comment I'd make is, it sounds to me like we've heard from the landowners of lots 1 through 5, but if the covenants are in the deeds for 6 and 7, like, have we heard, do they agree or object to this?
It says that there's.
Number 7 objects.
Number
Yes.
7 objects, okay.
Number 7 objects and number 8 objects, correct? Number 9. Have you heard from all of the other lot owners, Ms. McGuire?
So my firm provided notice to all of the lot owners. The only lot owners who I've been contacted by were the owners of lots 2 through 5, who are present by Zoom today. And then I was contacted by the owner of lot 8, who's not in agreement.
So lot 8 is not in agreement, not lot 9.
No, lot 8 and 9 are not in agreement.
Not
So it's not 7, I'm sorry.
8 and 9 are not in agreement.
So 8 and 9 are not in agreement, and I assume 8 is in a butter to 7.
But from what I understand, 8 through 12 don't have the covenants in their deed, actually written
Correct.
into their deed, it's just
1 through 7 does. Yeah, the board seems to be a little squishy on this.
I can't agree with
Kathy, and do you have any comments?
I'm really reluctant to touch this just because we don't know the original intent of either the board or the original
How it got there.
developer
Right, there's just-
of what their intent was. Without that, I mean, if the original owner had a better explanation, we'd have a clue, but I could see this being a nasty, tangled legal mess.
We don't have records from them.
No,
There's no Zoom recording?
we don't, unfortunately. We have,
Yeah, I don't.
well,
I'm not for that.
So this subdivision was done in 1890,
yeah,
and it included all the lots. 1 through.
I believe it did. It may have happened in phases, but if you look at the old maps, they say to match the two together.
When folks bought lots 5, 6, 7, 8, or 9, 10, they bought it with the expectation that there'd be no further subdivision within that
Correct.
Right.
subdivision. I don't think it's, if we don't have unanimous decision of all the people that own those lots, I don't know how we can make it a change and allow.
I'm terribly sorry, my phone, or my laptop died.
Oh, it happens to me too sometimes. What I'm saying is, I don't think it would be appropriate for us to approve this when we know that there are parties that when they bought the property, that they figured there'd be no subdivision on that particular, where they are.
Yeah. Does anybody on the board feel differently?
No, I agree. Well, in that, it's written.
Could I make a request?
The analogy would be you buy a lot next to an airport and you say you gotta get rid of the airport because the noise is bothering you.
Right.
Should not work that way. You should, if you buy something and you have an expectation that the person next to you and the person on the other side next to you won't have further subdivision, because it's in a covenant and in a deed. I don't think they should expect that to be maintained, unless everybody says that we're all okay with it, with a particular subdivision.
Could I
Go
make
ahead.
a request? I'd like to table the project.
Okay, to try and get more information, I assume?
Yep, talk to my client and
Okay,
see about steps moving forward.
okay. Trying to remember if we table, do we need to table to an exact date? We probably should, I think. Does anybody want to make a motion to table?
Can you withdraw the application and come back to us with it?
You could do that.
Then you're not on a time frame.
Pardon?
Then you're not on a time frame.
Okay, tabling would mean,
You'd have to come back at a certain point.
okay.
Is there anything
Any thoughts
additional
on
with
withdrawal
withdrawing?
table? Okay, yeah, we'll,
How much do they have to do if they withdraw versus hold?
If they withdraw, then when they have the whatever additional information and talk to their client, if they decide to resubmit, then I think they'd mostly be submitting what they already submitted, with the exception of the additional information or
Could we-
agreements.
Waive paper copies?
What's that?
Could we waive paper copies on the resubmission?
We did, it's actually been written into the,
Great.
but somehow we're still getting some of them. Go ahead, Mr. Seymour.
Yeah, Sebago Technics. I'm just curious, what's the difference between tabling as far as the timeline and withdrawing?
We have to have, if we table, we need to have a date by which you would come back.
It would probably be at this point, probably the June meeting.
June?
Yeah, I don't think we'd have time to do it before the May meeting, because that deadline's right around the corner.
Yeah, June, May. Ms. Day, do you have, Ms. Day or Laura Lee, do you have any recommendations?
3 months to come back.
3 months?
Yeah.
Obviously, if you can talk to the owners
Yep.
or get some history in this, and also talk to the owners that object, that might be helpful, but this board's obviously very uncomfortable changing that plan.
Understood.
So, all right, so is there a motion to table for 3 months? Moved by Ms. Cook, is there a second? Second by Ms. DiPietro. All in favor, please raise your hand. Now, this would be the regular members. Sorry. All right, thank you very much, everybody.
What time is it?
All right, next on the agenda is North Star Estate subdivision, preliminary subdivision plan, Isle Ridge Road, map 13, lot 52E. We had a pre-application sketch plan, February 3rd. We had a site walk, March 17th. So now we have the full preliminary application. The applicant appears to have standing and have sent notices. Do we feel the application is complete?
Yes, I would like to have better financial capacity, I always say
Okay,
that, but.
okay, so we'll get to that. Anybody else? Feel it's okay, so is there consensus, the board feels it's substantially complete? Does anybody wish to recuse themselves? Do we wish to hold a public hearing? It is planned to be an 8-lot subdivision followed by potentially another 8 lots. And are there people here that are wanting to speak to this subdivision, one in the back. So it looks like there's multiple people. What's the board's pleasure? Do you want to? Ms. DiPietro?
Yes, I think a public hearing, because we did have a number of people on the site walk with us, and there seems to be some interest here.
I agree. Okay, Ms. DiPietro and Ms. Cook vouch for a public hearing. Ralph?
I move that we hold a public hearing.
Okay. Maggie? Anything from our alternates?
Let's do it.
All right, so I accept a motion to have a public hearing. Moved by Ms. DiPietro, is there a second? Second by Ms. Cook. Any further discussion? All in favor? 5-0. This is usually when we allow the applicant to at least give us an overview, and if the board has any advice that would be helpful in the public hearing, to provide that advice. Just a reminder not to start the review. Go ahead, Mr. Seymour.
Thank you. My name is Jim Seymour, Civil Engineer, Project Manager with Spago Technics. Tonight I'm stepping in for Bill Garish, who is away on vacation. My understanding is the board did have a site walk back a few weeks ago. There were a few concerns which I will get into. This is map 13, lot 52E, Ohio Ridge Road, North Star Estates. True North Builders are here with me this evening if you have any particular questions to that development or their focus on what they want to build. This subdivision includes 8 lots on 19 acres, approximately 9.5. The dark green area in the rear on the right is retained for a potential future phase, but at this point it's undeveloped. There are 8 lots there in the front. They will be accessed by 900 feet plus of a proposed road. There were some wetlands on the property in the rear. I know from hearsay from I was not there, but hearsay from the site walk, there were some concerns about wetlands, and a copy of a wetland report has been provided by Chris Copey, who is a very astute wetland scientist, previously worked with the Maine DEP. The property drains basically south to north for this first phase, so all the drainage basically comes towards Ohio Ridge Road. In our development plans, we had 2 infiltration pond swales that are in the front on the 2 front lots. If I can make this work. Hey, look at that, we got technology. So there's a pond here, and there's also a pond here, which will collect the road runoff and treat that. However, there's still an excess of phosphorus, but we do comply with DEP and compensation allowance. With that, there would be about a ½ pound of phosphorus, which would require compensation. I believe that number is a little over $6,000. And I believe that would be through the town, eligible through LEA. Waivers, the applicant has requested waivers for the landscaping plan. This is a well-vegetated area, and also there's a huge, I say huge, but it's a little bit excessive setback of 75 feet from the road. Their plans are to build the homes as close to the road as possible, but also limit the amount of clearing on those lots for shade or for whatever purposes. So they're looking to retain a fair amount of vegetation. Therefore, it's kind of a moot point to have a landscaping plan when we've got adequate existing trees. This property was cut, I think, back 10, 15 years ago. Yeah. So there's a lot of new growth coming up that will take off relatively quick. That's probably 10, 12 feet high at this point. Site distance may be a concern. However, we have discussed about creating clearing here for the west side of Ohio Ridge Road that goes uphill so that we can acquire 400 feet of site distance. There's a stone wall there, and the expectation is that if we clear to that stone wall along the edge of the right-of-way, that it will alleviate site distance so that we get the 400 feet necessary for site distance. That may be a note you want to have on the plan, and it'd be the applicant's requirement to maintain that so that site distance is maintained through the longevity of the subdivision or the homeowners association upon being turned over to them. We're here this evening, obviously, to get feedback. And as the chair had said, there are aspirations in the future to do another extension, but for now, we're focused on the first half. So with that, we'll take any feedback and questions.
Okay, does the board have any helpful advice for the applicant for the public hearing? Kathy?
Yes.
Please get close to the mic.
Sure. So you stated that the applicants are interested in minimizing the clearing. Will that be placed on the individual deeds in terms of restrictions on clearing and the amount of supposed cleared area and impervious surface per lot?
I think typically what we have done is put a note on the actual subdivision plan in the past where we limit the amount of clearing and impervious surfaces for each lot as a restriction. So I think it would be a note on the plan.
Note on plan, okay.
That's typically how we've done it in the past. Because you're correct, we make bold assumptions on the amount of impervious driveway lengths and clearing limits for those phosphorus calculations.
Right. Well, I'll get to that later. Okay. On the deed, I noticed that it said something about a well and a windmill. Was that something that's... It's on the original deed, and if you could research what's going on there, because I couldn't find it anywhere on the plan.
It may be abandoned at this point, but
It could be. Yes. When I'm looking at the lots, and it looks as though most of the information that's being presented is the actual lot size as opposed to the buildable area on the lots, which is important information.
Yep.
So that could be corrected, because that's going to be important in terms of determining actual lot sizes.
Yeah, and again, there are, the only area with wetlands are down in the rear. So these lots would be total upland. So, but again, confirm that that is applicable, but I believe the entire lots for all of those in the front are upland.
Okay. Can you tell me why a Class D soil survey was done rather than a Class A soil survey, given the hydrology of the soils?
I cannot. It's just typical that we do the Class D, which is the typical
So
Cumberland
I
County.
might reword that question as, can you explain it at the public hearing, give an explanation for why Class A versus, or why Class D versus Class A? I forget exactly how you said it.
Yeah, and just real quickly, Class A is a real, I won't say, I never even want to use how much it costs, but it is a deeper dive into the soils. It's a much rigorous soil scientist investigation, plots, everything like that. It adds quite a bit of expense to the development, and typically, we do not find any difference between A and D.
So I would just suggest that, because we don't want to start the review here, that
you want to bring that to the public
that
hearing.
you could give an explanation there.
Right. Okay. Do you intend to open cut the outlet pipings for UDSF 1 and 2? And how are you going to avoid injuring the buffer strip at that point?
We'll look into that.
Sure.
And that is the outlet of the...
Outlets of the under-drained grass soil filters? Yes.
Basically, you want to know how we will limit buffer impacts.
Right. You might want to consider doing a new test pit on Lot 5, since it's right underneath your under-drained soil filter.
Okay.
And I know that you can't put a septic system there.
Okay.
When I reviewed the phosphorus calculations, they seemed to have, you seem to have used, this is going to be technical, Table 3.1 for subdivisions where you know how much clearing is going to take place and how much impervious surface, as opposed to Table 3.2, which is the one that you use when you have not defined how much impervious surface will be there and
Yeah,
how
no,
much.
one is
Yes.
for, to your
So,
point.
so
Yes.
just, I'm trying not to get into the review,
Okay.
sorry, Jim,
Right.
to interrupt you. So,
Into the weeds.
the question is, why 3.1, why using table 3.1
1 instead of
as opposed to
3.2.
3.2?
Right.
Okay.
Okay. Oh, and wells, locations of wells. It has said, you're gonna need this, that there was adequate location for the wells. I've got my drawings here, because this is not gonna make any sense until I do. Here we go. As you know, I do a 100-foot circle around all the test pits, assuming that that's where the wastewater systems are going to go. And the requirements for stormwater mean that you need a 100-foot setback from your underground soil filter to any private well. Therefore, if you look at Lot 1 and Lot 5, you're going to be really tight in terms of wells. Just wanted him to be aware of that, or you can look at that kind of thing.
Okay.
Okay. So, location of wells and why, I guess. All right.
That's my major questions so far.
Jessica?
Just I know there were, at the site walk, people were mentioning traffic and that there's a lot of speeding on that road and how more traffic might impact. That was something that came up, and I know you want the waiver for the landscaping. But as far, like, if you're gonna be cutting back a lot for that site view, if coming out of the road, you're gonna build onto Higher Ridge Road, will there be a buffer of trees
Yes,
still?
what we did was if we cut back to the stone wall, the 15-foot buffer would commence at the stone wall, so you'd have the same 15-foot.
Okay, so there would still be a tree buffer
Yes.
from the Higher Ridge Road to the
Right.
first house? Okay, thank you. That was all I had.
Okay. Maggie?
My only comment was about the cutting trees for the sightline. It might just be helpful to have a photo or like a Google Maps street view just to understand.
So do you want the limit of clearing on the subdivision plan like we've had for some others? Is that what you're asking, or just to be clear?
Yeah, and maybe just submitting like a screenshot of like Google.
Panoramic view. Going up.
Yeah,
I got
just
you.
for folks
Okay.
to understand what the impact will be.
A photo montage or something,
Yeah,
sure.
doesn't need to be like.
Yep.
That's all I have.
Rob? Angie?
Yeah, the financial capacity, that needs to come from a bank or another institution, not a construction company. And there are, in the application, it states what we're looking for.
The application form.
The application form states exactly what we're looking for, and this is just for the sake of consistency because we see these financial capacities all over the place.
Okay.
So we would like to have what's in the application.
Okay. There was a letter about farmland and a 50-foot setback, which was quoted as a state requirement. There's also a standard, which is standard O, I think, of the statutory ones. It says no harmful impact to farmland. So if you could just review that and address that. I don't know if you're going to need to talk to the other owner. I took a very quick look at the rules for the department, and the way I understood it was what counted from, in terms of that 50-foot setback, was the actual farmland, not woods and other things.
Right.
So just, I don't want to get too, that was just what I saw, but
Yeah,
I think it's really.
We did start investigating, because we
Okay.
just got the notice ourselves, and I think we had some questions about how the notification process went, but I won't burden the board with that.
Okay.
But I did reach out to the University of Maine Agricultural, they have a mediation line to understand how that works with
Yeah,
property owners.
I'm looking for an answer to the requirement of
Yep.
that 50-foot setback and where it has to start and where it ends.
Yep.
This is not being planned as a planned unit development, if I'm correct? Even
Correct,
though you
yep.
you may have a second phase?
Correct, it's not a planned unit.
Okay. And then I had a similar question or similar comment. Just make it very clear what the intent is with the buffer on the front buffer there, where you're creating extra site distance.
Right, and I think we've addressed it and discussed it and how we're going to do that, but we'll clarify with narrative.
The other comment I had, and I'm certainly not Kathy or an engineer, but the phosphorus calculations, do they need to take in, and again, this is, you don't need to answer this, do they need to take into account the other properties, assuming, do the phosphorus calculations for 1 through 8 lots need to take into consideration the potential future building on 9 through 16? I don't know the answer to that question.
I do, but that's okay, we'll take the question.
And the subdivision plan should have contour lines. I know there was, the contour lines are on the grading plan, but the subdivision plan, it's important because that really, it's easier to look at the lay of the land and what it is, what it
Easy
is.
enough, it's just a layer,
Gonna
it's
be.
easy enough to turn on.
Yeah. And the fire chief, your impact statement refers to Dugway Road. I think that was the one for Middle Ridge. So if you could correct that.
It's in, or we email correcting that after.
Okay, all right, good. Because Middle Ridge said Sweden Road. But is Sweden Road correct if it's off Ohio Ridge?
No.
Or is it
No.
Route?
No.
That's
Swe-
the last hydrant at the intersection of Sweden and North High.
Right.
But this is on Ohio Ridge.
But that's the
further
closest
down.
to
That's the
Oh,
Hydrant.
that's the
Yeah.
closest.
Oh, Sweden,
Far.
Sweden Road is Route 93.
oh, okay, I got you now. Gotcha, all right. So that's, all right. And in terms of the waiver for the hydrogeological letter, I'm squishy on that. Board can't make a decision here tonight, but the letter that was provided for Middle Ridge was extremely useful. And with this many units and number of abutters and the slope of Ohio Ridge Road, I would advise that it's done. Anything else? I think that's it. I would encourage, Ms. Day?
Public hearing date?
June? No, April, May.
May 5th?
May 5th.
Okay.
I'm very sorry, I know we're probably wrecking the schedule right now.
I think we're okay.
All right. Feel free, well, I know there's abutters or people that were noticed here. Feel free to reach out to the engineer or through Brenda and Laura Lee to the engineer.
Do we need a motion for that?
Yes, we do. I'll move that we'll have a public hearing on May 5th. Is there a second? Second by Ms. DiPietro. Any discussion? All in favor? 5-0. Okay. Alrighty. Next on the agenda.
I wouldn't leave the house.
Is 5E Stonewall Hollow subdivision. This is the final, this is the final application. This is on South High Street, map 9, lot 36. We go through the same procedure here for a final. Do we believe it's substantially complete? They do have notice, they do have standing, they did provide notices.
Yes.
Okay. Does anybody wish to recuse themselves? Do we wish to call a public hearing? I would recommend we don't need to because we already have thoroughly studied this and had a public hearing and a site walk. Okay, and I'm assuming we don't want a second site walk. First one was
Not exactly.
Yeah, that first one was about fixed.
All right, so the floor is yours, Mr. Seymour.
Thank you, board members. Jim Seymour, civil engineer and project manager from Sebago Technics, representing Fielding Properties LLC and TKT Holdings LLC for the Stonewall Hollow development. This has been before the board a few times. My understanding is that this is the final, and we were really geared upon acquiring the DEP approval for stormwater, which has been included in your packet. We finally received that. Just a refresher, this is 12 units on 5.25 acres. We did provide you a letter with the revisions that we made, and I'll just quickly go down through those. As I mentioned, the DEP stormwater management law and NRPA permit by rule for wetland impacts have been included as well. Catherine, we have already acquired the GP for this one because one of the owners is a contractor, and we were able to get that done. Long-term maintenance is by the property owners. This is a rental property, so the ownership will be in control of the maintenance. New lot numbers, there are no new lot numbers on this. And we did update the buffer. Where's my magic highlighter here? This is like my new toy. We did improve the landscape buffer here. We added some plantings there. There was a waiver of that landscape buffer with the understanding that we would fill that in with some plantings. It's on a steep slope, but the board required or asked that we update that landscaping plan to show some plantings to help hold that together, one, but also protect these owners as well as the other owners. The other owners actually live further away. There's actually a decent buffer between the properties, but we'll take responsibility for establishing ours. Go through the list. The rest is really, there is one utility easement over the existing road for utilities and for CMP and water. This is served by public water, and we will have a pump station at the end, which will be a private pump station, which will come back into North High Street. There is an extension that was left as part of the work done by the town, and we have acquired permission to tie into that line. So with that, we hope that we've met all of your conditions that were left over from the preliminary approval, and tonight we gain final approval.
Okay. So, Mr. Seymour, it sounds like there's no substantive change to the subdivision the preliminary subdivision plan that
No.
DEP required, or
Nope.
any other?
Nope, same number of units, same length of road, same stormwater.
It's all been approved, the preliminary, they're all approved.
And you
Say
grant us
again,
pre-
Rolf? I think I need hearing aids. Say again.
Preliminary, with the preliminary, all those items are approved.
Yes. Kathy, anything?
No, when I saw everything coming through, it looked good.
Jessica?
No questions, no.
Maggie? Ralph?
Nope.
Angie? Okay, so I don't. My one question was, were there any changes? I already asked it.
I said we got 7 in a row.
Yep.
So, just going to what were conditions in the preliminary for the final. We need the stormwater approved by DEP.
Right.
Road name and entrance permit, which is in progress, I guess.
Yes. I believe they want to go with Stonewall Hollow Drive, but that has to be approved, so.
The long-term maintenance plan. Did you turn in a long-term maintenance plan?
That was part of the stormwater permit from the DEP.
Okay. Okay, I see it. I see it on there now,
Yeah.
sorry. And what was, remind me, what was updated in the landscaping plan?
Actually, I have. In this area here, we added more plantings because there was a void.
Correct.
in the
Okay, I
buffer,
remember
so
that,
we
yep.
filled that in with landscaping.
All right. And the MD, okay, single utility easement is on the site plan. All right. The final subdivision plan says that you should have subsurface wastewater disposal system approval, but that goes through the code enforcement officer, is that correct?
Well, this will be
Yeah.
on,
On the sewer system.
it's on Puck Sewer.
On sewer.
Right, sorry, that's correct. Just making sure we did everything we're supposed to do here. Okay. So to make sure we're proper, we just need to go back through the criteria, statutory review criteria, and the municipal ones, and just make sure that those still apply. And what I would recommend to the board is to pull up the preliminary plans, finding of facts and conclusions of law. Because since nothing been presented, that nothing has changed other than the landscaping. Is that correct, Jim?
Yes.
Okay.
So, so anyway, we should just go through this and be sure nothing has changed from what we said before. And I'm just gonna mention them, and you, does everybody have it open? So you can see it?
The finding of facts for Stonewall.
Yeah. So if you think the landscaping plan change or any data you saw from DEP changes anything, please say so. Pollution, sufficient water, municipal water supply, erosion, traffic, sewage disposal, municipal solid waste disposal, aesthetic, cultural, and natural values, so what I would do in the final here is I refer to the 12/28/25 subdivision plan sheet submitted in January, which is the prior landscaping plan. So in the final, I think we would just denote here, same exact language, but refer to an updated plan. Does that make sense to the board? Comprehensive plan, financial and technical capacity, surface waters, groundwater, floodplains, freshwater wetlands, farmland, river, stream, or brook, stormwater. I think this is the other one that I would recommend we change on the final. This would just say that it's been approved by DEP. Makes sense? Like phosphorus concentration, impact on adjoining municipality liquidation harvesting. And then for the municipal criteria, phosphorus export, relationship to community service, retention of proposed public sites, natural and historic features, traffic impact, shoreline zoning, easement for drainage, do I need to put something about the easement you mentioned in there? Hold on, let me just pull it.
Yeah, we've got it on the subdivision plan. It's an overlay of basically the road, but it's shown on the subdivision plan.
So there is an easement for drainage now?
For utilities.
Okay.
The drainage is private owned.
Okay, and then I would just say under H, utilities, where it says utilities are able to be provided for such residents, for each residence, just say an easement is, a utility easement is noted on the plan. Does that make sense to the board? Okay. Road or homeowners association. Did you say the maintenance
The
thing
maintenance for the
has?
stormwater is all included in the DEP. This is a private entity at this point. They're responsible for all maintenance. It's an apartment.
So it's going to be done by the owner, it's
Correct.
not a homeowners
Right,
association?
yes.
Okay. Minimum lot size and frontage, monuments, road signs, I think I would I would suggest to the board that since he doesn't yet have the authorization for the road, that that's just a condition that they have to get a permit. Is that okay?
Perfect.
Yep.
Non-conforming roads, sidewalks, water supply, fire protection, sewage disposal, surface drainage, long-term maintenance plan, I think here we would need to refer to the maintenance plan that's been updated. Perimeter buffer. Now we're on the land use standards, allowed uses, dimensional standards. I won't go over each of them. You take a look, and if you have district-specific bulk standards do not apply. The conditions that were there, one would, so if you go to conditions, please.
Stormwater's all set.
So one is stormwater, DEP approval, so that would be
That's all set.
removed.
Right. Road name and entrance permit?
What's that? That would,
We still
that would,
need the,
that would
well, the
stay.
road
That would
name.
stay, yes.
Right, stay. Number 3 basically goes away.
Correct. And the other two stay the same, I believe.
Yep.
So that's it. So the standards, anybody keep track of that? So the ones that changed were,
Yep.
they're still the ones that changed were stormwater,
One disappeared.
aesthetic, cultural, and natural values. Road or homeowners association, there's not going to be a homeowners association, so
No,
that
goes away.
changes. We talked about the road sign. And long-term maintenance plan will be updated. That sound like everything?
Yes,
So,
I haven't got those.
any other comments by anybody?
That looks good.
So I'd accept a motion to tentatively approve the final subdivision plan as presented with a condition concerning obtaining a permit for the road name and sign. Moved by Ms. DiPietro,
Yes.
Second?
second by Ms. Cook. Any further discussion?
No.
Ralph, you look like you have something to say. All in favor? Okay, we're good. 5-0.
Thank you very much.
Congratulations.
Thank you.
Well, we haven't gotten, you have McDonald Motors, right?
Yeah, that's just an update for you as far as where we are with the DP, so.
Would it be okay with you,
100%.
Royce and Mark? If
Yes,
we-
absolutely.
Is it okay with the board if we skip the agenda and just keep Mr. Seymour up there and
He's
talk?
not going
I ain't
anywhere.
going anywhere anyway, he's got me.
Okay.
You got me, he's got me, I'm going nowhere, I'm stuck.
Okay, so you could maybe speak to McDonald Motors?
Yes, it's just an update for the board. We have received stormwater comments, we have responded. Those were minor technical issues, but the one big one that did come out of it, which we did resolve, was with the application of the DEP, it's a site location, the phosphorus calculations, because we had to look at both properties because it's common scheme, so we had to look at the actual dealership as well as the new lot we're creating. With that, we were over a little bit on phosphorus. While we complied with the acceptable practice of compensation, the DEP came back and said, no, compensation was not allowed to go to the watershed, which is Otter Brook. However, we had documentation from their own website that said LEA was an administrator of that compensation, sent that back in, DEP agreed with us, thank you. So now that is with the DEP being, my understanding is being processed for the other items beyond stormwater. At this point, we reached out to the analyst. He's no longer with that particular department, so now they're shuffling to find us a new analyst to continue the review. So we might be 2 or 3 more months. We're not sure. We haven't had any contact since then to find out who's picked up the permit to run it over the goal line.
Okay, all right, and if I remember correctly, the board tabled this for 3 months, hoping you would have the...
Right.
Right. So we didn't do a findings of fact and conclusion of law yet. We tabled it instead of amending it so that if it changed, which it sounds like it did, you didn't have to submit an amendment. You would just submit what changed.
Yeah, it didn't change anything from a standpoint of what you're reviewing or any of our features. It was more of the calculations themselves, some factors within the calculations.
Okay, so, but it changes the dollar, does it change the?
I don't think it changed anything on the dollar amount. The question was, could compensation be allowed to be paid versus meeting the standard? DP initially said no, but then they realized that LEA has jurisdiction over Bridgton, Harrison, and Naples for the various watersheds. So I reached out to Colin, more than willing to take it. He's got some Otter Pond projects, so he's more than willing to accept that, and we've communicated that through the DP.
Okay, so do you still want to stick with the original decisions?
Yeah, like I said, nothing has substantially changed from that. So again, we're just waiting for the final write-up from DEP, and without a contact person on the project, we're in la-la land, so it's frustrating. It's very frustrating. We're dealing with this with DEP across many projects right now.
Okay, all right, that's fine. I mean, I know Mr. McDonald's kind of in a hurry. I mean, not so much in a hurry, but this is taking a long time because of DEP, and he's got cars he couldn't take delivery on, he said.
Yeah, so, I mean, yeah, he is anxious to get this over the finish line. We are too, but we're at the mercy of the state at this point.
Okay.
Any update on where the speed limit is?
Ms. Day, is there any update on the potential change in the speed limit? I think last time,
I haven't heard, I can do a check-in with the town manager, but last I heard, they were still reviewing it, but I think something's supposed to be happening this summer, so I can get...
if you could double check that.
And I'm not sure whether last meeting or the prior meeting, but we do have DOT approval for the entrances.
Okay.
And we'll provide that. Well, we can provide that now, we can provide it with a package link and then the rest of the things.
Maybe it's best to do it, I don't know, it's up to the board. Do you want the DOT approval in the file now, or do you want to wait until they have everything?
Just wait, they have.
Yeah, just easier, I think, to bundle and keep it together.
Okay.
Bundle like Progressive. It's getting punchy.
We did actually, deliberate on everything we could.
Yes.
So, and Laura Lee has actually sent me draft findings based on that.
Okay.
So we'll take a shot at trying to get those.
Yeah, if you could just give us a list of outstanding things that we need to further address, and that way when we come back, we can line item those. Make
Okay.
it easy for you to follow as well. We find that's usually the easiest for the board and for us to go through this.
Hold on a second, maybe I can. Oops.
Where enough time has lapsed, we all need a little refresher.
Right, my thought is it'd be good to get it written up before
Sure.
the brain cells, die. I don't. In the draft Laura Lee has sent me, there were no conditions of approval
Okay.
other than,
DOT and DEP.
Yeah.
Two biggies. Okay, well, we'll go through the final application, and when we have that DEP permit, and just kind of go through it to make it easier for you to follow.
okay. And Laura Lee and I will go ahead and finish this findings of fact and conclusions of law as much as we can, so maybe that can get reviewed at the same time as when you bring the updated information, and is the board okay with me writing it as if they've got the DEP approval and there won't be any changes?
Sure.
Okay?
Okay.
I'll do that so that maybe it can be ready to roll when you.
We hope. Fingers crossed.
So we need to keep tabling this. Do you want to go another 3 months?
Yes.
Okay. So, could somebody make a motion to table? Rolf?
Second. Angie made the motion.
Angie, Ms. Cook first, Rolf second. Any further discussion? All in favor?
Thank you very much.
All right. Next on the agenda is not Middle Ridge subdivision.
You have it on there twice, you know.
Oh, yes, I'm sorry. Next on the agenda is Middle Ridge subdivision, the final.
No, we also have South High Street and Reynolds. Is that the same?
Oh, okay, yeah, I'm sorry. Not even reading my own writing. New business, South High Street, Brunel Lopez subdivision. This is a sketch plan. This is not a formal application, so this is to give the applicant friendly advice. Go ahead, Mr. Lopez.
Thank you, Madam Chair. Good evening, board members. I'm here tonight. I'm Mark Lopez, 438 Commons Drive. We're here tonight with the sketch plan. It's very preliminary, and it's preliminary for a reason, because there's one issue that we're going to have to discuss. We're showing the two building envelopes that we're showing there now would represent two duplexes. I believe we can put 5 units on this parcel. We've had the wetlands screened. There's no wetlands on the site. This site is serviced by town water, so we will not have any issue with central water. What we have to decide is, will one septic system be central sewer? I believe it is. I believe the way that the draft decision for Middle Ridge was written would support that. In the draft decision, it said the board disagrees with this conclusion as to the context in this application indicates central is central to the subdivision development, i.e. a single water supply and a single septic system for all proposed dwelling units. So that's really what we have to decide tonight is, do we meet that? And it's preliminary for a reason. I want to cross this bridge and have some predictability in the outcome of what we're gonna do here before I spend a boatload of money and tell me that it doesn't comply.
That's fair.
Questions?
So the proposal is for currently 4 dwelling units, 2 duplexes, right?
Yes, ma'am, yeah.
But you're considering maybe a third
I'm considering
building.
a fifth unit.
Okay.
Because
So
with 80,000, we have 80,150 square feet with the septic loading that's available to us, we can put up to 10 bedrooms on that parcel.
Okay, so 3 buildings?
Yes.
Okay, and yeah, so then the septic, are there septic systems that can accommodate that?
Absolutely, yeah.
And I guess then does the land support a septic tank of that size that would
No,
be needed?
there would be individual tanks, it would be 5 tanks, 1 common leach field, similar to
Okay.
Mountain Road. And it's quite common, actually,
Okay, so it would be multiple septic tanks?
Yes.
1 leach field?
yes.
Okay. Okay.
Okay, I think the correct terminology now is for anything that's over 2,000 gallons of wastewater per day, and the septic application is called an engineered system now.
Correct, we
It used to
wouldn't
be-
cross that threshold.
Right.
We'd be 1,200 gallons a day.
1,200?
Yeah.
Okay, so you wouldn't make it into engineered system territory.
No. It's usually 90 gallons per bedroom per day, but when you put multiple dwelling units on one lot, it goes to 120. So in an 80,000 square foot lot, you can have 10 bedrooms.
Maggie?
I have a question about sewer extension heading out there. Does anybody know? Are there any plans to go that far? I don't think so
If you
currently.
can do it, I'm all for it.
I
It's a
know
long way away.
there's plans to pursue funding, so that's why, but I don't know what the actual
I
plans
don't know
are.
the exact destination of that.
Okay.
I mean, I can check into that.
If we could find out.
Yeah, I
that
know
would-
they have a couple of proposals.
Yeah.
Yeah, we're a long way from there, from where it ends, yeah.
Yeah, I'm pretty sure it is, but I definitely can check to see what they expect.
Yeah, and no plans for like is the lot not big enough for a planned unit development?
Say that again, Maggie?
I'm just thinking about planned unit development versus 3.
Yeah, it would be a condo. It'd be condo, yeah, I don't know how you want to term it, but this would be a 5-unit condo.
Okay.
My only other comment, just looking at the street view, there's some beautiful old oaks, and it would be great to keep some of them if possible. Or plant, I don't know where the road is in
Yeah, and I
comparison
mean,
to the.
honestly, we may come off of Courtyard Circle, we may not even come off of the main road, so. We have to really figure that out, what.
What's this we?
Well, you went south of me fast.
And the only other consideration is just the entrance to the church across the street and thinking about traffic, but that,
Yeah, if we use
Cross
Courtyard,
that.
that wouldn't be
Yeah.
an issue. And I don't know what our right side of Courtyard it is, shown as a town road, we do abut it. I haven't looked into that yet. The water's already been stubbed to the site, it comes from South High Street. And these would be housing that's affordable. That's the goal. It's not affordable housing.
What are the unit size?
The duplex units, Ralph, would be just under 1,000 square feet each, and the single family would probably be somewhere, the single unit would be about the same. But, all 2 bedrooms.
So the single family be 2 bedrooms as well?
Yes. Yeah, we limit it to 10 bedrooms in aggregate, so if we had 4 2-bedroom units, that gives us 2 bedrooms left for the last one. Actually, we might be able to get a 3-bedroom, because we have 80,150. Have to check that. Might be able to get another bedroom. We'll figure that out.
Anything else, Rob?
That's it.
Angie?
Anything?
Erica? I have had similar questions to, I guess, Maggie. So, so if you decide to come in from wherever that other street is,
Courtyard Circle?
yeah,
Yep.
okay, so then you would need some sort of permission maybe for that, you're not sure?
I don't know that. We'll have to check and see what our rights are to it. It is shown as a town road. We do abut it.
Okay.
But that's on the town map, right, Courtyard Circle? Yeah.
And since it's a condo, by the regs, it requires a 25-foot perimeter buffer? Are you planning on that?
Yeah.
Okay.
Yeah, we got plenty of room.
And
And it
I
shows
would
it.
suggest when you come to show the third building?
Yes, we will, yeah.
Okay. And so what let me understand the sewer. So it's going to go to the town water, which obviously is central water. The sewer is, each unit will have a tank,
Each unit will have its own tank, one central leach field.
but, okay, which, unlike Middle Ridge, which has separate leach fields for each lot, this will have one leach field for that entire lot.
Correct.
Jessica, are you?
Is this something that we should have our broader discussion about definitions first, before we give a decision?
Well, Madam Chair, with all due respect, you've issued that decision in the findings of fact and conclusion of law from Middle Ridge, where you say, central to the subdivision development, i.e. a single water supply and a single septic system for all proposed dwelling units. That's exactly what we're doing here.
Yeah, I just want to make sure that we have the right discussion so that we don't give you the wrong answer. So
Okay.
we don't have to do a repeat.
That's what we're here for.
Yeah, I think, the only other way to do it is to have one tank for all 5 of those houses, but what kind of complication does that create?
I don't even know if you can do that. Because then it becomes an issue of maintenance. Everybody is supposed, when a condo situation, when everybody has individual tanks, they're responsible for pumping their tanks so that it doesn't all go into the leach field.
Anybody have any other thoughts?
Hopefully there's sewer.
I'm with you there.
That would be obviously be the best.
Yeah,
I'm not sure there will be.
it's not gonna happen in the timeframe that's gonna help us, that's for sure. Those things move at a snail's pace.
Okay. I kind of agree with Jessica, we should take a close look at that, but again, this is non-binding. My perspective is this is a step up from what Middle Ridge was, where there was clearly, 4 lots and 4 systems, and this is, everything's going on one lot, so it sort of changes the context of what you're looking at. So that's kind of my feeling
I just have
now.
a curiosity question. How big of a leach field with regard to square footage do you need for multiple tanks?
How big of a leach field do you need for 1,200 gallons per day?
It all depends on.
What's a regular leach, 20 by 40 is a regular leach field, right, 800 square feet?
Yeah, this would probably be.
So you're gonna need 4 times that, you're gonna need 3,200 square feet, so 40 by 80.
Okay.
Yeah, it's not as big as you think.
It all depends on what system you use, or, use Elgin's or use Chambers, it has an impact on the bed size.
And when are you thinking of bringing this to the board?
Next month.
All right. Ms. Day, come on up.
I only have one quick comment. It is on a corner lot, so I think the 75 foot needs to come off both roads.
Say again, that means what?
We know
I
that.
think the 75 feet needs to come off both roads, because when it says it's
And we know
corner
that.
lot,
We know that.
Okay.
Where is the road? I don't see it on this.
It's down at the bottom.
Courtyard's there, it's not very well defined there, but we can meet the 75 from both roads, we're aware of that that requirement.
So I'm still trying to figure out
Which they have.
what court we're.
Yeah, so that'd be, well, it'd be
It's across from
interesting.
the church, Andy.
Oh, gotcha,
Yeah.
okay,
It
okay.
w- it went out back, it's, if you're looking at South High Street, it's to the left of the cottages development.
Gotcha, okay.
But the access, if it did come from that side, would be interesting if there's a third place there, and then you also have septic, so, I don't know.
The septic, the leach field can go in the 75-foot setback. I mean, there's plenty of room.
Yeah.
This is
Yeah.
not gonna, really that dense for,
Yeah, so if you came in, if you did come in from the road whose name I can't remember,
courtyard.
would you just go in a little bit and then just take a,
I would
on the
just put
map,
dri-
go straight
I
up?
would just put driveways. I'd probably turn the houses to
Oh,
at
the
least.
different direction.
Yeah, I just put
I
three
got
driveways.
it. So you turn them a different
Or two
direction,
driveways.
and then the septic would be in a different location.
Yeah, the septic can be at the back. The septic can be in the buffers. It can be in the 75 feet between the, between the road and the setback line.
And there's already a house on this parcel?
There's an old foundation. I think it's a shed. There's no house.
Okay.
One more quick thing, if it's going to have a shared driveway, we do need a road name too, for that.
Shared entrance, separate driveways.
Yeah, road.
Same? Separate entrances, separate driveways.
Separate entrances?
Separate
no-
driveways.
She's the expert on that. I don't think I have any further comments.
I think well.
Go ahead,
The
Maggie.
preferred design would be from Courtyard Circle, feels like potentially a better.
Yeah, I
Say
don't
again?
disagree. I don't disagree.
If possible, I know.
Yeah, I don't disagree.
Yeah.
It's a lot better than turn it out onto
Yeah.
South High Street.
So, what did you just say, Maggie?
Just that I would prefer, and I think it would be better for multiple standards to come off of Courtyard, even
To
if it's
come off
three
the Courtyard
entrances
one,
instead of
okay.
another.
Because it kind of eliminates the
Entrance.
traffic.
Yeah,
And then it eliminates the road
It is
issue.
shown as a town road. I don't know if it's a private town road or if it does access a house out in the back, and there was a couple condos out in the back there as well, and it goes into the cottages afterwards.
Oh.
Yeah.
I'm all for making those connections. I think it contributes to like continuity and connectivity, and so that's
Generally,
fine.
that's a state road, generally the state will probably request it be, if you have access to Courtyard, to have the entrance off from there. They prefer it off side roads versus the state road.
Mhm.
They may approve it, it goes, they're wishy-washy sometimes depending on.
Yeah, if I don't have to get,
Yeah.
if I don't have to get an entrance permit from the state, if we have the right to access it from there, I would prefer to do it that way, right? It makes more sense to do it there.
Anybody else?
So I'm not sure I'm getting any clarity on where we are here. The big question is, do we meet that standard of central sewer? And I think if you look at what you gave tonight in terms of the draft, findings of fact, conclusions of law, we absolutely meet it. We have a single water supply and a single septic system.
So you would be proposing that the single septic system is the 5 tanks collecting the sewage,
Yep.
going through a series of pipes, right?
You
have to have
It would
different
go to
pipes.
tanks, then it would go to a distribution box, and then it goes through different pipes into the leach field.
Okay.
It's the same, I mean, the Mountain Road project has 17 units and 3 septic systems. The Little Mountain project that was approved by this board has 29 units and 1 septic system. 29 septic tanks, or 23 septic tanks, whatever it is.
Yeah, I think Mountain Road has 3 septic tanks and
3 leach fields.
3 leach fields. It has 2 water supplies for all 17, if I remember correctly.
They-
But each tank, if one fails the other tank, and it's been approved as a public water supply.
Correct.
each tank, if one fails, the other one has the capacity to serve all 17.
Still supply water, yeah, there's two wells that are drilled there, there's 5,000 gallons and two 2,500 gallon tanks. Royce and I went up there and Dan was kind enough to give us the tour and share all the financial information about that system with us, so that we have it as an option.
I mean, I think looking again at the findings there, and this is just a thought to the rest of the board, and I do agree with Jessica, maybe we should try to discuss this. We do have a workshop April 21st. This wasn't on the agenda, but maybe we can spend a little bit of time on it. What's supposed to be on the agenda for the 17th is review of the STR document that's been put together by Ms. Day, which is a draft. I'm thinking that's not going to take very long. And then we're supposed to get started on the affordable housing stuff. Maybe as part of that, we could be discussing central sewer and central water and considerations for, different types of subdivisions, basically. Ms.
Right, because the new housing laws are yet again adding more terminology here. Yes, I was looking at LD 1829, and in their subsection, notwithstanding Title 12, Chapter 423, in designated growth areas or served by public water and public, special district, or comparable sewer system. And that's going to have yet another different definition, because publicly owned treatment works are required under the Clean Water Act to provide a minimum of secondary treatment, which you don't get with septic tanks and leach fields. So this is going to be another tangle.
You can get secondary treatment.
No.
Not necessarily the aerations.
I mean,
aeration and recycled and.
the board could discuss this more, but I would just say in the findings, as they're written right now, okay? There's two quoted definitions of central sewer. One of them says, central sewer system, also called public sewer or municipal sewer, but that's also, that's not like it has to be, is a shared wastewater system that collects sewage from multiple properties through underground pipes and transports it to a treatment facility. The other one says collection network and disposal system, central sewage treatment for a single development. So I guess one way to look at this is you are collecting sewage from multiple points, which is the 5 tanks, and it's going to a central treatment. If you're doing it not in the context of an urban situation, but you're doing it in the context of this situation, which is one lot. So that's just my thought that's on the table. That would be one way to look at it, which would
This is where we need a planner. Just bring that up.
But we really can't give a commitment, but we can, I'm throwing out the idea that possibly could, in my mind,
Madam
possibly.
Chair, I'll end the way I started, with the board wanting to be consistent. You have written into this finding of fact and conclusions of law that I didn't comply because I did not have.
I'm not disagreeing with you.
Okay, then if we're not disagreeing with me, why can't we get a consensus that says, yeah, we do comply here with this?
We can, but it's not binding.
Okay, I'm not looking for binding, I'm just looking for you guys, this is what we're doing with a sketch plan. I don't want to spend $20,000 to come in here and fight with you guys later.
And I have to agree with him on that. I mean, they spend, these people spend a lot of money to come before us.
Tens of thousands.
My only point is it says right in the ordinance that this is non-binding discussion. I'm suggesting that there's a way to interpret central sewer system based upon the definitions in the findings of fact that we haven't approved, that, in my mind, maybe it's parsing words, but it works for, it's not parsing words, actually. It's actually using that definition in the context of a single lot as opposed to multiple lots. So that's where I come out. I don't know where the rest of the board members come out, other than, I think Jessica would like us to be I think we should discuss it, because there seems to be very number of permutations of this at our next meeting, and Kathy thinks the same thing. But I guess for the rest of the board, just so Mr. Lopez knows how you're looking at this, or at least has an idea. We don't have to commit, but...
Non-binding, I'm in agreement that it's non-binding. I just want to know what the feeling of the board is.
Right. My feeling is if you can pull a good term from the subsurface wastewater rules for a system that serves multiple residences on one lot, because I know that at the sizing that you're talking about, that's possible and doable. Any technical terms you can pull from there in your application that we can refer to will be most useful.
Does shared count?
I don't know. I've never seen it in the subsurface wastewater rule, but I've never looked that hard for shared.
Anybody else? Any other comments?
I think that's exactly why we need to have that discussion in the meeting.
Yes, I feel as though we are being pressured to give you a decision right now after we have already agreed that we do want to have discussion for you. Please give us the time to have that discussion.
Okay.
Thank you.
You kind of made the decision in this document that you handed out for Middle Ridge, in my opinion. Now, I had a second sketch plan that I didn't bring because I didn't want it to be construed as threatening, but we talked about options last time.
Right.
An option for this site is 4 mobile homes. And I've already talked to the code officer. We can put 4 mobile homes there, each on 20,000 square foot lots. That's Plan B.
I don't know where trees go.
Yeah.
So I'm not asking you to be pressured, but you know what? We're under a timeline here too. We're in business.
But you are pressuring us.
Okay,
I don't
I'm sorry you
appreciate
feel
it.
that way.
I mean, I kind of feel like if I was spending tens of thousands of dollars, I would be pushing for some kind of...
Thank you.
Some kind of result or answer or something. He's just asking, should he go forward with this? If he does A, B, and C, are we going to allow this? I know you want to have discussions.
We can't, well, go ahead, Nancy.
I mean, I know that we need to have discussions on clarity and consistency and things like that, but, I mean, he's bringing it to us and he's done his homework. He's telling us that this is like this one, so, it's like, I mean, how much more money is he going to have to spend for us to figure it out?
I'm sorry you guys feel pressured, but you wrote this.
I don't feel pressured.
This was written into the decision for Middle Ridge that says, because we don't have a single septic system and a single water system, we're not central. We have this here, just like they had on Mountain Road, okay, just like they had on Little Mountain, okay? We're asking for the same treatment, the same interpretation, and the same application of the standards.
So it feels like we have a plan that doesn't require you to spend a lot of money, and, that feels fair to me, that our next meeting we'll have this discussion. I would like to have, before that meeting, I think it would be great if a formal planning entity could weigh in on this, like GPCOG or something. Other communities are dealing with this. There's a lot of implications right now, for good and maybe unexpected, about how definitions around shared, central, all the words. Non-public, private sewer systems, like how we're gonna have to change things for housing laws, what it is gonna mean, and I think I just desire an understanding of what that then will mean in terms of outcomes. And I think we can have that discussion at the next meeting, hopefully, again, with some prep to go into it, so it doesn't take too long, and we can like have a good discussion about it, and then do this, and not try to drag it out, like there's no
Yeah,
intention of this, I think, like, it's, I think there's just, the decision we make around this, any definition that we decide on has other implications, and that
Right.
feels important to just be thoughtful about.
Does it really? I mean, if I was gonna subscribe to that theory, I would say the decision you made on Mountain Road or Little Mountain should have implications here.
So
Not you, but the board. There's three
I
members of this board
understand
that
that,
were
but
there.
a lot is changing right now, and I think that matters too, right?
It does,
and
but you know what's not changing? We need affordable housing. That's
I
what's not changing.
completely agree. I
We need housing
completely
that's
agree.
affordable.
I think the scope of the conversation keeps changing, and we have a plan.
So folks, okay, so I'm not feeling consensus at the moment. I made a suggestion, I don't feel consensus. I don't know that the board has been able to look at, well, I read it. Ralph, I've just mentioned that Mr. Lopez understands it's non-binding. So things could change, which would then cost you money, obviously, if you built it a certain way. I also understand we want to discuss it further. The only thing I would say is each application has to be judged on its own merits. Context and the type of development, all of that, you know, that has to be judged on its own merits. We can't start saying, because we did this, we do that. We also can't be wildly inconsistent, so it should be consistency in some level of interpretation. So, Rolf, you look like you wanted to say something.
No, I just think that we need to have a discussion as a board. I understand what you're talking about. The decision we make here doesn't only affect you, it affects other developers. And we've got to make a good decision. And I think that, honestly, I think it's some semantics in the way the language is that we need to get fixed. Make it consistent, as you talked about. But give us that 2 weeks. Hour or 45 minutes to discuss that. And I think that we could probably come up with a decision that the board will be happy with and you will be happy with.
I appreciate that, Ralph. Thank you. So when is that meeting?
We have a meeting on the 17th. Now, we're supposed to do the findings for the other item on, it just gets complicated because we can't.
We're going to do the findings on the preliminary based upon after we review the table.
So we have the conversation first, and then we do the.
And then once we're done with that,
Yeah.
that's going to help us get into the conversation.
Yeah.
Are we on a different, we're talking about South High Street, or we're
Yes,
talking
but
about Middle
remember, so we have to be careful that we're not set, we have to be careful that we're really judging each application on its own merits, and then that we're not confusing a workshop discussion with a prior decision. So I think what you're saying is, we're supposed to go back, look at the tape, see whether or not we agree with Mr. Lopez's addition, his request to add to the minutes, and then if we disagree, then we move straight to the findings of fact. If we agree, we add it to the minutes, and again, we go straight to the findings of fact, and we decide whether anything material would change in the findings of fact. Does that make sense? And that is separate from a workshop.
And then in the workshop, or as an agenda item on the workshop for that meeting, we're going to make a discussion as well.
So you're suggesting adding that portion before we start discussing?
Do we ever have meetings that are less than 3 hours?
We were for a long time.
We were. Jessica, we joined at the wrong time.
Yeah. We were getting out of here a lot earlier for a while. Okay, so let me get this straight. So on March 17th,
April 17th.
excuse me, April 17th. I just want to go backwards, I guess, okay? On April 17th, we will have an agenda that first addresses the request for an addition to the minutes, and then we will finalize the findings of fact and conclusions of law. All right? After that, we will open our workshop. And the first thing we will discuss on the workshop is the short-term rentals, because we have a draft ordinance.
And that's on the 17th.
For the 21st.
21st, I said the 17th, geez, I
Yeah,
am
you
really
did
bad
say
with
the
dates.
17th.
So is it-
I have plans for my You know, I was on vacation for 2 weeks, this is what happened.
So it's the
2 weeks
21st.
from now.
The 21st.
Okay.
So after we, is that okay with you?
I might not be here, but don't let me hold you up. I'm not here.
We want to wrap it up too, I promise.
What's that?
We want to wrap it up too, I promise.
Okay.
On the 21st of April, we will finalize the findings of fact and conclusions of law after we've listened to the tape and decided whether or not to incorporate
The request of the change
the
made.
request for the change, or anything else you think needs to be in the minutes, okay? That's your opportunity. Then we will move straight to the findings and approve those, change and approve them, whatever, okay? And then we will move to the short-term rental ordinance. Then we will move to start to discuss affordable housing, and we can, the objective that, if you remember originally, was going to be that we just have a list of things initially that the state is saying, and to understand that. So I think we can do that, and we can discuss this, and yes, it's probably going to be a 2-hour meeting anyway. So that would mean that Mr. Lopez's, I should say, Royce, because Royce is involved in the other project, that would mean that we'd have a decision on the findings for Middle Ridge, and we'd at least have a start on what we think is the right, what we think the definitions are, or the issues are in the subdivision, and then out of that would come, I think, does this potentially work or not? Remember that if we were to change anything in the subdivision, we have to have a public hearing, blah, blah, blah. So, but I would hope after the 17th, there's more uniform clarity from the board.
Yeah, I'm not sure we should have to change in the subdivision. I mean, I'm just looking at what you guys are giving us.
I totally understand what you're saying, but I'm just hearing what the rest of the board members are saying. I get it, looking at that one definition of central sewer system, which says you have multiple houses or sources, and they go into one spot to be treated. That's what it seems like you're doing there, but the board is hesitant to take that right now. So, but that's, I'm telling you where I am on it.
Yeah, I just want, good planning should seek the best outcome. That's
Yeah.
what I would say.
And sometimes that takes thoughtful discussion and collaboration, and that's, I
Best
think, what we're
outcome
trying,
might not
that's
be the
certainly
outcome
my
that makes everybody
intention
happy,
here.
unfortunately. Best is broad. Best is what's best for the town. Okay,
Okay, thank you.
now we're moving on to one more item, is that correct?
So, what do we, I guess we just.
See, even you are confused now.
Well, no, I guess we kind of just said we're putting this off
Yeah.
till.
So we're putting South High and.
Well, you,
We're done with,
so with the, so the question is, you submitted essentially a letter, or Mr. Seymour did, excuse me.
Was this
we
just,
don't have a final decision on Middle Ridge. The preliminary
Oh, on the preliminary, so we can't do the
We can't
final.
go under the final.
Right.
Yeah.
That's the way I understood
Right,
it.
I think.
Okay,
Yeah.
I got it, yep. So,
That means we're done.
almost. I think we are pretty much done. Let me just go back to the agenda. Oh, there it is. Okay. Royce, if your father isn't here on the 21st, would you be able to be here?
Is that Tuesday?
Yeah.
Yes, sir.
I think it's.
And Jim, we would
There's
probably
anybody.
need you to be here,
April 21st?
at least for the first half hour.
I'd say so.
Okay. We already did McDonald Motors, so does anybody have anything else besides you want? Ms. Day,
Really quick, because I'm ready to go home.
come on up.
Very, very quick. I did get an answer from the town manager, early 27 is when the light's going in, and the speed reduction is included in that, but hasn't been approved. It will be with that light change when they do that, but it's early 2027. Then
Yay.
before that happens.
What about the traffic light? Oh, you were?
The one that's needed, yes, the traffic light.
Oh, that's exciting.
Reduction is being part of that.
So do you need a motion to adjourn?
Yes,
I move to adjourn.
Angie moves to adjourn. I think Rolf seconded it, all in favor?
Aye.